All right, good morning, everybody. Welcome to an oral argument session at the 6th District Court of Appeal. My name is Dan Traver. Please be advised, this is streaming on YouTube. I'd like to introduce the rest of the panel. With me today is Judge Keith White and Judge Josh Mize. We have one case on today's docket. It is case number 23-252, Foggs Investment LLC and Stanley R. Fogg Jr. versus Michael Osorio et al. Can I confirm first, Ms. McAllister, can you see our clock?
Yes, I can.
Ms. Curlick, can you see our clock, ma'am?
Yes, sir.
All right, so Ms. McAllister, if you don't tell me differently, I'm going to assume that you would like to retain 5 minutes for rebuttal.
I actually was thinking 6. Is that okay?
You can choose whatever you like. 6 is fine.
6.
And ma'am, the floor is yours. You may proceed.
Good morning. My name is Colleen McAllister. I represent appellants Foggs Investment LLC and Stanley Fogg Jr. I've already told you I want to reserve. May it please the court. Fogg's Second Amendment complaint should not have been dismissed by the trial court because it alleges enough factual matter taken as true to suggest the required elements for violations of procedural due process under 42 U.S.C. section 1983. The second amended complaint, we need to remember, concerns a single code enforcement case that was opened on January 24th, 2020 and closed by code enforcement without notice to Foggs on March 31st, 2021. Foggs has alleged in the second amended complaint that the county employees acted unlawfully when they issued a stop work order that violated Collier County ordinance, and they acted unlawfully and in violation of Foggs' constitutional right to procedural due process when they canceled the final hearing on a contested notice of violation, removed the case from the special magistrate, and denied Foggs the opportunity to argue a question of law in the final hearing, and denied Foggs findings of fact and conclusions of law and a final appealable order as required under Chapter 162. 1983.
Is there any case you're aware of where any court in the state of Florida has found there to be a property interest in a court order, irrespective of whether the court order grants any other relief?
Well, the 11th Circuit has said that you have a property interest in a zoning violation, okay?
Correct, but in this case, the government entity was no longer pursuing the zoning violation, right? So had he gone to a final hearing, he could have got one of two things. He could have won.
Correct.
And in that case, he'd be in the same position he is now because they wouldn't be coming after him. Or he could have lost and would be in a worse position because then they would be coming after them. So the only thing it seems you're seeking is not any type of actual relief. It's the order itself, the edification of the order, because they've already stopped pursuing the claim against him. So is there any case you're aware of where a property interest in a court order has been recognized?
Yes, I am. And first, let me clarify. The second amended complaint seeks damages. It does not seek an order. The order, we're past that point in this litigation that we can argue about the order. The 11th Circuit, as I started to say, said procedural due process attaches to zoning actions. And this case was about a zoning action. When the case was closed on March 31st without a final appealable order that would provide process to remedy any procedural deprivations, that then was when the constitutional violation became actionable under Section 1983. In other words, once we had no remedy at law, then as the Section 1983 became viable. Now, with respect to property.
You're speaking are from the damages resulting from a lack of a final appealable order?
No, we are seeking damages under Florida law. The county, we had a right to be, no, what we're seeking is the damages from Fogg spending a year contesting the zoning allegations in the notice of violation, because it'd been doing business like that for 30 years. And we're seeking injuries for impairment of reputation, personal humiliation, out-of-pocket losses, and other harms. The Supreme Court has said Section 1983 damages can include out-of-pocket losses, other monetary harms, as well as injuries like impairment of reputation and personal humiliation. The second amended complaint alleged damages as a consequence of both the stop work order and the contested notice of violation for loss of business revenues, loss of reputation and embarrassment, alleged damages including costs and attorney's fees expended to contest the notice of violation that should have resulted in a final appealable order. In cases such as Kupke.
The damages you just cited from that year-long process don't result from the lack of an appealable order. They result from that year of process. And what you're challenging in your complaint is the zoning board canceled the hearing, that you didn't get that final appealable order. But those damages exist irrespective of whether or not there was ultimately a final appealable order obtained.
Correct. And if you look at Kupke, for instance, Kupke v. Orange County, that was the big discussion in that case in the 11th Circuit is, what is the element of damages that they're claiming? And the court found that such damages resulting from state action deprive. Excuse me.
Actually, challenging is failing to give you that final hearing and a final order, or at least finish the hearing because the hearing began. But the damages you're citing don't result from the lack of an order or the lack of the final hearing. They result from the prior year of litigation, but that's not what you're challenging. You're challenging the canceling of the continuation of the hearing and the lack of an order. But those aren't you don't cite damages that flow from that action.
Respectfully, Your Honor, what we are alleging is that because they denied us a final appealable order, and because they denied us the right to seek redress in the circuit court for what happened, we have been damaged in that we pursued this hearing under state law, and we were denied our opportunity, and therefore we have suffered damages under Section 1983.
Client have received that final appealable order and been entitled to seek review in the circuit court, is one of the things the circuit court could have done in the context of that review is award money damages for loss of reputation or loss of work due to the year-long litigation process?
No, but we entered this hearing with the full understanding that in challenging the notice of violation, we were going to expend resources to get a decision on whether Mr. Fogg's business operation was operating in coordination with the law or whether he was violating the law. And that was what we sought. We understood the process that was happening. We understood the cost of contesting. And we would have been fine up or down on a final order. If there were procedural issues that we needed to raise, we would have had the ability to raise them in an appeal to the circuit court.
But you would not have been able to seek the damages that you're claiming now.
No, he wouldn't. But he wouldn't have had the expectation to seek these damages had he received the order that prompted those expenses in the first place. And that's really the argument. And that's why cases like Kupke found that those damages give rise to a deprivation of property and a complaint for damages under Section 1983.
Counsel, would you please address the executive discretion argument? I'm struggling to see, if we see it your way, what that opinion looks like. For example, would an opinion reversing saying have to say something along the lines of everyone who has a complaint filed against them has the right to an order?
No, Your Honor. As the county argued originally, cases like Duterte have set out certain specific discretionary functions of a code enforcement department that can end a code enforcement hearing without any resolution. And one of those is dismissal. But they didn't dismiss here. They never dismissed. And in fact, they took it away from the special magistrate and continue to monitor him, investigate him, and enter data in the record, and ultimately claim that he came into compliance with the contested notice of violation. We would have been left, quite frankly, when the property transferred, if they had just decided to throw up their hands and dismiss, we would have been left with no remedy, and that would have been within their discretion, but they didn't do that. Instead, they continued the case. They continued the case for more than 3 months and ultimately ended the case by finding Fogg in compliance with an order that it was contesting in front of the special magistrate. The issue with respect to sovereign immunity is the trial court found that it could not interfere with the actions of the county employees under sovereign immunity. The Supreme Court actually considered this issue in a Florida case, and the case was Howlett v. Rose. And the court said the county employees cannot hide behind state law sovereign immunity for a federal constitutional violation to get a dismissal of a 1983 action. And in this case, the Supreme Court struck down the Florida Supreme Court decision that found a Section 1983 suit on state law sovereign immunity grounds was dismissed. It held that conduct by persons acting under color of law that is wrongful under 1983 cannot be immunized by state law. The Supreme Court found Florida's sovereign immunity law violated the Supremacy Clause by operating as a state law defense to a federal law. The elements of and defenses to a federal cause of action are defined by federal law. And again, that's from Howlett v. Rose. All persons who act in violation of federal rights while acting under color of state law should be held liable for damages. The trial court also cited the language in Trianon that the judicial branch must not interfere with the discretionary functions of the legislative or executive branches. To the extent the trial court relied on Trianon's separation of powers argument to grant the motion to dismiss, I would suggest the trial court erred. This was not a discretionary function. There is absolutely nothing in Chapter 162 or Collier County Ordinance, which mirrors Chapter 162, to suggest that code enforcement employees can interfere in an ongoing special magistrate proceeding, cancel a hearing set by the special magistrate, take it away from the jurisdiction of the magistrate, and enter their own order on how it should be closed. There is nothing in the law that allows that. So it can't be considered a discretionary function or an executive function because there is absolutely no basis in law for them to do what they did. And that's why I argued in the initial brief and the reply brief that sovereign immunity is simply not an argument here. You know, Mr. Fogg had a constitutional, his hearing was about a constitutional deprivation of property because it was, and that's the 11th Circuit has decided that about Florida law, and they decided that way back in the 1990s. And he had every right to continue his hearing. So when the county now tries to hide behind sovereign immunity, it cannot show that it is not simply using sovereign immunity to defend itself for taking away a constitutional right that Mr. Fogg had. Have I made that clear?
Council, the Koepke decision, I guess a couple of points. This is the 11th Circuit unpublished decision.
Yes.
Is that correct? You agree we're not bound by that?
No, you're not. But understand that I would ask the court to understand here that there are very few code enforcement proceedings where there's even counsel present at the code enforcement proceeding. So to have to try and find on-point case law that, on-point case law about code enforcement proceedings, and there's actually nothing about this case that I could find in any case law. You have to defer to the cases that are out there. And that is the case that talked about this particular kind of damages and whether they would become a property damage under Section 1983. I would
Isn't
also,
the Kepke case a different, distinguishable factually? I mean, I'm looking at the Kepke case. I looked at it before briefly and looking in more detail since your argument seems so focused on it. In that case, there was allegedly a deficient pre-deprivation hearing that resulted in a fine that was paid by
That's
the
correct.
plaintiff.
right. But when you think about that in coordination with the fact that the Supreme Court has said that 1983 claims can include costs, out-of-pocket costs, and of course, attorney's fees are costs of pursuing the complaint. The two of the real focus in Kepke, of course, was on whether the court was even looking at the right argument they were making about damages. And what they ultimately found was that the complaint had at least stated enough sufficient allegations that it should have gone forward past the motion to dismiss stage and been developed further. And of course, it's not only just the cost damages here. Mr. Fogg suffered a great deal of reputational harm by what went on here. And
What would have changed, counsel, had the hearing occurred?
what would change?
Let's take your facts one step, everything that you've alleged, if that in fact happened.
Okay.
And then in response to what you're contending is unauthorized canceling of the hearing, someone decides, well, we're going to have the hearing anyway. We're not going to listen to staff recommendation. That
Correct.
happens in city commissions and county commissions all the time. And so we're not going to listen to staff's recommendation. We're moving forward with the hearing. Hearing's held. You agree that whether the result is up or down for your client, that may be substantive violation, but it's not procedural, correct?
Correct.
And so the hearing's held. So no matter what the outcome is, the hearing's been held. How is your client in any better position than he would have been without the hearing?
Well, first of all, understand that when we decided to challenge the notice of violation, again, as I said, the violation was finding violation for activities that occurred at Fogg's for more than 30 years without any claim that they were violating county zoning laws. When we decided to contest that notice, we understood that the outcome could either be yes, you are, or no, you aren't. And what we sought was that determination. And had we received that determination, we would have moved forward from there, And we had, when the property went under contract, of course, there was discussion about what to do, but we had made a fairly substantial case. And the key thing about the fourth hearing was that the special magistrate had admitted over objection this zoning determination letter, which was the only evidence they had that there was any zoning violation. And I objected. And in our closing argument, I said,
Counsel, I know you've been responsive to the court's questions, but you're very far into your rebuttal time. Would you like to keep any?
Oh, yes, I'll wait.
Okay, we'll leave the 2:20 for you. Ms. Kurlik, floor is yours, ma'am.
Thank you, and may it please the court. My name is Rachel Kurlik. I represent the appellees who are employees and representatives of Collier County, Florida, and have been sued in that capacity. There are a multitude of reasons, each one of them able to stand on its own, that we argued to the trial court, that we've argued in our briefing, as to why this case was properly dismissed by the trial court. And as the panel has recognized, and Ms. McAllister's argued, this is the 1983 due process case. Both causes of action, counts 1 and 2, allege due process violations. And the first element of a 1983 claim is a deprivation of a constitutionally protected property interest. So of course, the threshold question is, and that's probably why Judge Mize, you asked it so early on, is did the plaintiff sufficiently allege a violation of due process when they haven't sufficiently alleged a deprivation of property? And that's exactly what we're dealing with here. Foggs is very candid in what they're alleging the alleged property interest is, and that is the failure to have a final appealable order, including conclusions of law and findings of fact. I'm not aware of any case that makes that a property interest that is subject to due process protections or that would trigger due process rights. And Ms. McAllister was not able to cite any in response to the question on that point. The other sort of angle on this that's been taken is, well, there's these case notes in the code enforcement file that say the property was brought into compliance and that somehow that constitutes a property deprivation. Well, it doesn't on its face, but I would point out two things about that, and this is all in the attachment to the complaint Exhibit A. One, it says the property owner has brought the property into compliance, which the property owner at the time of that case note was no longer Foggs Investments, someone else. And that's important because these code enforcement violations follow the land. They don't follow the owner. And that is the reason for the rules that provide that these hearings must be suspended when property changes hands, in order to give the new owner an opportunity to bring it into compliance, because otherwise it's not fair to them. Otherwise, they might be deprived of due process if there's a continuation of a hearing that would create a fine or an obligation to remedy something against someone who's new to the enforcement proceedings without giving them that opportunity to cure it. Now, I suspect Ms. McAllister might bring up in rebuttal that the way in which the case notes are written make it seem like they're directed to Mr. Foggs and not to the new property owner, because the new property owner was a school. And I would have to concede that it is unclear at best. The case notes are messy, but in any event, those case notes do not impose an obligation upon either of the plaintiffs. They do not impose a remedy of any kind against either of the plaintiffs. They don't require them to do anything, and they're not binding upon the plaintiffs at any point into the future. So to the extent they were even wrong, and I don't know that they were, they don't deprive them of anything. And so there's no due process connected to that. The process that they were entitled to in any event was followed. So the process is set forth in section 162.06 of the Florida statutes, and then the relevant Collier County ordinance is almost identical to that. So I'll talk about them together. And that's the process that explains what happens when the property transfers hands between the time of a notice of violation and a hearing. Now, what happened here is weird. It's kind of an anomaly, right? The hearing lasted a long time. It was multiple days, and the property changed hands in the middle of it. So it had started, but it hadn't ended. And the statute and the ordinance do not speak to that. They don't tell anybody what's supposed to happen in that situation. And the trial court addressed this, and this is where the Massey case comes in, because Massey is a discussion about how the courts sometimes have to use a common sense application of the statute and the ordinance to fill in any procedural gaps. It's exactly what we have here. We have a gap in what the process is when there's a mid-hearing transfer. So let's use our common sense and see what would happen. And if the county's decision-making was in line with that common sense approach, then even if there was a due process, right, which I don't think there was, it was met here. Because the county's approach said, okay, we're in the middle of a hearing. We haven't made a decision yet. We haven't imposed any remedies, fines, or decisions one way or another. And we've got a new owner who's going to be stuck with whatever we do. So the most logical common sense application of this process is we're not allowed to dismiss the hearing yet. We're going to continue it and give that new property owner an opportunity to come into compliance. That's exactly what happened. So process was followed if it was even authorized at all. I'll touch on a couple of the other reasons that we raised the trial court in our briefing. We do believe this is an advisory opinion that they're seeking. I've actually looked at paragraph 37, of their complaint. And paragraph 37 of the complaint really tells us what they're trying to do here. And they want a vindication in the court of public opinion. That is what they're saying. They're saying there was this stop work order. There was a effort on behalf of county employees to basically disparage Mr. Fox. And we have to take that as true for purposes of this complaint, of course. But if that's the case, they can determine if they have some other remedy, but it's not a due process case. It's not something that entitles them to an order or an appeal that they can then, deliver to people who may have questions about their reputation. Sovereign immunity, separation of powers also bar these claims. Under DeTournay, which was discussed, governments can decide when and whether to prosecute. And that's exactly what Fox is asking for. They're saying that Fox had to continue and complete the hearing, even when the county determined that there wasn't a reason to do that. I do want to mention, and I'm not sure if the court picked up on the nuance or not, but in response to one of the court's questions, appellant argued that the county entered its own order after closing the code enforcement case. That's not alleged in the complaint. That's not accurate. What the county did was suspend the hearing, cancel the hearing, and ultimately close the case and enter case notes accordingly. That's what the complaint shows, and that's what the facts are, which is certainly not the same as entering an order. The last thing I'll mention, unless the court has any questions, is there is a standing issue in this case. What's alleged in the complaint is that Stanley Fogg is really complaining about an alleged harm to his business, and that business is Fogg's Nursery and Mulch Supply, Inc. That's the business that operated upon the property owned by Fogg's Investments, LLC. So Fogg's Investments, LLC, the property owner, was the party that had rights under the code enforcement process while it was pending. But the harm that's being alleged is the harm to the business, which is not a party to this case. So even if we get past all of these other issues, we still do have a standing issue. So I'll just conclude. Yes, sir.
The standing issue I thought you were going to raise when you said that is whether or not he had a right to appear at the hearing if it continued. Like, had they continued the hearing, since he was no longer the owner, whether he had a right to even appear at the hearing.
And that is another reason. And I don't know how the county would have treated that or whether they would have allowed him to be heard or not. Because again, the property interest is the property owner is the respondent in the code enforcement case. That's just how it works. That's just what the law is. So I guess there are two standing issues, not just one. It can't be the law that the courts can step in and force county governments or any government to continue a case when they deem it to be concluded. Imagine if a defendant in a criminal case wanted a jury verdict. They wanted an opinion of a jury to vindicate them and clear their name. A prosecutor would be barred from null crossing a case that it no longer believes in. And the system would frankly fall apart. And that's exactly why separation of powers exists. It's why the DeTournay holding is what it is. And why the court should, one of the many reasons why the court should uphold and affirm the dismissal. Thank you.
Are there any further questions?
No.
All right, Ms. McAllister, rebuttal.
Yes, first of all, DeTournay doesn't provide any discretionary authority to do what happened here, which is remove a case from a code enforcement special magistrate simply because apparently you don't want it to be in front of her and you don't want to have other hearings. The case was closed with notations in the case note of voluntary compliance. And if you look at the case notes, now these were not the public case notes. These came from the assistant county attorney, and they're in the record. And if you look at the last page of the case notes, you will see that not only.
Ms. McAllister, can you hear me?
Pardon me? I can't hear you.
Not hear me?
I can hear you now, sir.
Oh, okay. I'm sorry. Yeah, I have a question about that.
Okay.
Assuming again, as we must take the well-pled allegations as true, if what was done without any authority and they actually had a duty to have a hearing, wasn't your client required to avail himself of the remedies under the law of the great state of Florida, which would be perhaps a cert petition or a mandamus petition, before he could bring a procedural due process claim under the U.S. Constitution?
I did consider that. First of all, I couldn't find any grounds for bringing a cert petition in the middle of an administrative hearing, but I did consider mandamus. The problem with mandamus is that mandamus requires either that the court be asked to enforce a ministerial duty. There is a part of mandamus that you can ask for the court to enforce a discretionary authority where someone is abusing their discretionary authority, but neither of those things were true here. This was an entirely extra legal action. There is no discretionary authority in any statute for a code enforcement employee to pull a case from a special magistrate once it's exercised its discretion to prosecute it and refer it to the special magistrate.
So are
And
you
so-
saying that you may have had a remedy seeking a petition for a writ of prohibition or a quo warranto?
I didn't think so because the court, and first of all, we didn't exactly know what was going to happen here. For example, part of the statute requires if there's a transfer, although it didn't apply here because this hearing was held, the transfer occurred well after the hearing was in progress. But there is a provision in, for example, section 125, which is the same statute as chapter 162, only applies if you choose to take the citation to a court of law as opposed to a code enforcement board or special magistrate. The proceeding is the same. It's very cut and dry. If it transfers between the notice of hearing and the hearing itself, the court gives the new owner a chance to bring the property into compliance, substitutes that party, and proceeds with the hearing. There is no other remedy. There is no other procedure. You know, I've argued
Thank you,
twice.
ma'am. We let you answer that question over allotted time. Thanks to both of the parties for the thorough briefing and argument. The case is under advisement and will be adjourned today.
Thank you.
Thank you.